Hello, my name is Betsy Brandborg. I am the Bar Counsel at the State Bar of Montana. It has been my job for 20 years, and I've been watching the access to justice movement grow from non-existent to where it is today, and it's made some phenomenal progress. And the piece that is critical to the access issue is limited scope representation. Limited scope representation, which is my topic, and then I'm splitting this topic with Janice Doggett, who will introduce herself. Limited scope representation is also known as unbundling. And in the legal world, the only constant is change. We've got a changing legal landscape. We've got these people who are called triple LTs. They're the limited licensed legal technicians in Washington state. But in Montana, what we have most recently is admission on motion. So suddenly we have quite a few more lawyers from other states that did not graduate from the University of Montana practicing law in Montana. And so these new models are available to us in Montana, having been imported from other places, primarily California, for the limited scope representation. And in Montana, this was a hard-fought battle. Limited scope representation has two sides. The primary side for Montana's purposes is the nonprofit pro bono side. That was the driving force behind why we have limited scope in Montana. The Montana Supreme Court's orders in 2011 made it clear that their decision was driven by a desire to address the unmet legal needs of low and moderate income people. Justice Nelson had a limited dissent, but he was very concerned about the second side of limited scope, and that was the for-profit side, which has just taken off, also in Montana and nationwide. But the for-profit side of it is really beneficial to us because the people in that arena have created a number of forms and checklists that make it so much easier to provide pro bono and other limited legal services. So as I said, the limited scope representation was specifically ordered by the Montana Supreme Court in 2011, and they did two different orders. One order had to do with the changes in the rules of civil procedure, and the other had, the second order made 3 changes to the rules of professional conduct. And for purposes of talking to non-lawyers, it's important for you to know that the rules of civil procedure are about the rules of the process, how we do law. And it includes Rule 11, which I'll get to in a moment, but Rule 11 is critical. And so it's the cookbook, it's the process. Those are the rules of civil procedure. The 3 changes to the rules of professional conduct are specifically directed to lawyers, because you can violate or fail with a rule of civil procedure, and that just means you're not going to go forward with that portion of your litigation. But if there is a challenge in the rules of professional conduct, you could end up having your license suspended or revoked or being disbarred. So for lawyers, the changes to the rules of professional conduct are critical. So I'm going to talk about the amendments to the rules of civil procedure first. So that's the MRCP 4.2. One of the barriers to pro bono was the concern that all the clients in litigation are clients forever. When a lawyer enters an attorney-client relationship with the client can always fire the lawyer, but it's really very, very difficult for a lawyer to fire a client. You have to have the court's permission, and you, in many cases, have to have the client's permission. If the client doesn't give permission, occasionally the judge will let you out. But one of the big challenges to limited scope was that people were saying, because limited scope has always existed in some form or another, But what was happening to the lawyers is they would show up and they would do a limited representation, and because they were a known entity to the judge and to opposing counsel and to the court structure, people kept contacting that lawyer, and that lawyer would say, I am done with this project. That was a limited scope representation. And the judge and opposing counsel would say, too bad, we want you to stay in, and you're required to stay in. And that created all sorts of heartache and unhappiness, and essentially was starting to serve as a barrier to having lawyers serve even in a limited capacity. So the big change in the world of the rules of civil procedure was that they added an entire new section, all of Rule 4.2, to the rules of civil procedure. And what it says, and I'll let you read it, and I really want to say to anybody that's watching this video, don't take my word for it. Go back and read the 2 orders. They're only 3 or 4 pages each. They're very simple orders to read. You want to read the dissents too, because there's some additional information there that's relevant to how you might want to do things. So I'm going to paraphrase 4.2, and it essentially says, limited scope is now an option. If you, and when I say you here, I'm talking about you, the lawyer. If a lawyer files and serves a notice of limited appearance, then the lawyer is not on the hook for purposes of all future filings and service. You are, when you're being a lawyer in a limited scope representation, you're there for the specific purpose of what you and the client have agreed to do. But you're not in it for the long haul, and we'll get to the details on that in a minute. And what you want to do in particular is look at subsection B. It says limited representation is permitted, providing, or what it's saying is that the limited representation is permitted, and it does not constitute an entry of appearance. And an entry of appearance is the glue that holds you in the litigation. If you've entered an appearance, then you're in it. But if you have a limited scope agreement, then, and the court and the opposing counsel know you have a limited scope agreement, then you get to get back out. That is a watershed change in how law has been practiced since the beginning. The second new rule of civil procedure is 4.3. This is the how-to, the notice and withdraw and their impact. So again, you want to read these rules. The limited scope has a fair amount of paperwork, but it's quick stuff and the forms already mostly exist. To start and end a limited scope appearance and to get the protections that were in the Rule of Civil Procedure 4.2, the last slide, you need to file a notice of appearance, and when you're done, a notice of completion. With full representation, as I said before, you are not allowed to terminate an attorney-client relationship until both the client and the court agree. But in a limited scope appearance, what has happened, and this is where the checklists and the forms are pivotal, the client has already agreed in their initial paperwork that this is a limited scope agreement, and so in that agreement it is saying, as soon as I'm done with this task or this portion of this project, then we're done. And the court's not going to contact me about you, and the opposing party and the opposing counsel are not allowed to talk to me about that. And in particular, the court cannot pull you back in. So these are protections in place that are specifically designed to encourage limited scope, and they're specifically designed to encourage pro bono representation, because it is so very much easier to do some representation for one portion of a litigation project. The third rule of civil procedure adds a new section to Rule 11. Rule 11 are the sanctions that can be imposed by a court against an attorney and the parties. And sometimes the court can get so frustrated that the sanctions are directly levied against the attorney in the matter. So Rule 11 changes, and the new section to the Rule 11 is a big deal because 2 things that did not previously exist are now permitted. The first thing that I think is critical is that ghostwriting is permitted. And ghostwriting is when, for example, if I had someone that was in crisis and they needed some immediate representation, I could draft the documents for them. I could write the brief for them, but my name and address and who I am appears nowhere in the document. That's a huge change in the rules of civil procedure. The other huge change is that in Rule 11, the attorney is allowed to rely on the facts submitted by the client. And that's the case unless it's pretty clear you're being snowed. If it's not adding up, if the story that the client is telling you is not adding up, of course you have responsibilities to go and look into it and make sure what the client is saying is accurate. And the language in the rule is if you have reason to believe that the client's representations are false or materially insufficient, you should do some additional investigation. And that's a watershed difference simply because under the current rules of professional conduct and rules of civil procedure, if you file something that doesn't have a basis in fact, or you didn't investigate for purposes of determining whether it was appropriate or was actually just truthful, you have an obligation to go out and confirm what this client has told you about these issues to make sure that when you make the allegations, they have a basis. And when they don't, you're just wasting everybody's time, opposing parties, opposing counsel, and the court's time. But under this Rule 11, it gives you a certain amount of latitude to listen to what the client is saying, use that material, and if it smells really bad, yeah, you got to go look. But if it seems to have a basis in fact, you get to run with what they gave you. My mom used to say, you got to dance with who brung you, and that's about right. So now there are also 3 changes to the rules of professional conduct. And the first one is that the Supreme Court added an entire new section to Rule 1.2. And that has to do with how the scope of representation. So that's the whole point of calling it limited scope. The sections A and B are the same as what they were before 2011. And they're the ones that say you have to abide by the client's decisions. And you get to take action that is impliedly authorized by the client, and that you're not endorsing your client's choices or distinguishing, the rule also distinguishes your choice from your client's political opinions. That's all well and good, that's still there. But what they did was they added this new section that requires a limited scope agreement and allows a limited scope agreement if the client's giving informed consent in writing, unless, and there are some very specific exceptions here, and Janice will be talking about the types of programs where the limited scope agreement does not need to be in writing. You can give some quick advice, and she'll be talking about those opportunities. But for an attorney in the trenches, whether you're for-profit or non-profit, most often you're going to want to get the limited scope agreement in writing. It's just a good practice. The second change to the rules of professional conduct is to 4.2. And this is the section, A is the same, and that's the section that prohibits lawyers from speaking with a representative party without the consent of the lawyer. So what everyone who's gone to law school since the beginning has learned is that if someone on the opposite side of you is represented by counsel, the last thing you want to do is talk to that person. You have to talk to their counsel before you talk to them. So that's the Section A, and that still stands. But Section B is the new language, and what it says is the critical part. A person opposite you in litigation, a party opposite you in litigation, is considered unrepresented unless the lawyer of the limited scope representation client has said in writing that the client is represented. So what happens is you are now free when you're the lawyer opposite a limited scope client is you get to talk to the client because now they're unrepresented. You knew they were represented for a specific period of time, but when that specific period of time is over, you no longer are required to just talk to counsel. Now you are permitted to talk to the client. The third rule change to the rules of professional conduct is the addition of all of Section B. So Section A is pre-existing and Section B is new in 2011. And it's the same idea. The limited scope client is deemed unrepresented unless you know that they are represented. How do you know that they are? There's a writing. And let me talk about writings for a sec. If you look at the rules of professional conduct, there is a definition section, and they have a distinction between a writing and confirmed in writing and informed consent and informed consent in writing. So when you're doing this, you want to know those differences. So you should take a look at the rules of professional conduct in the terminology section and check that out whenever you're a little iffy on whether you need to have a writing. But here's the good news about a writing. It can be an email, it can be a text, it can be a letter. Well, we're used to letters, right? And it can also be a voicemail. Now, I wouldn't rely on a voicemail as a writing. I would make sure I get it in writing somewhere in like an email. But a lot of people do consider writing a voicemail if they are able to put it in their file. And given today's technology, that's something that you can do. But you want to have a writing that indicates that you and the client have agreed that this is a limited scope representation. So there are some really fabulous checklists and materials. When you do a limited scope retainer, what you're going to want to do is have everything that's listed on this list in your fee agreement. You don't have to draft a new fee agreement because there are these amazing resources. And I'm going to talk about more of them in a minute, but I want you to start writing down right now Sue Talia's name. Her last name is spelled Talia. And the other lady who's done a tremendous amount on this is Stephanie Kimbrough, Kimbro. And if you Google Sue Talia limited scope, you're going to get directly to all of the forms which are available for free and all of the alternate fee agreements that are available for free and all of her checklists. Because if you do this by the numbers, you'll be safe. But the minute you slide off the rails and you don't follow the checklists, then your client gets confused, and when they're confused, you get bit if you're the lawyer doing the LSR representation. So when you're talking to your clients about, for example, their retainer agreement, a lot of clients will sit there and they're listening to you and you're throwing a lot of information at them, and they're probably a little elevated in their in how they're thinking, and they may have a little bit of an adrenaline flow going. And so as a result, when you're telling them these important things as you're going through your checklist on the fee arrangements and their need to be candid and the time frames, they're going to be sitting there going, That doesn't cut it, because you can tell when people start doing that they're not listening. So here's the critical thing. Say, what is your understanding of our relationship? And then, what did you hear me say? And explain this part back to me. Because a lot of people, the reason they're with lawyers is they're in crisis. And when you're in crisis, it's really hard to hear important information because you're trying to tell your story. And the attorney is probably in a position of pushing back a little bit because they don't necessarily want all of those details, but they need the details. But if they're trying to do a limited scope representation, they're trying to help you channel or help the client channel to the issue. So don't let any client sit there and say, when you're working on the limited scope agreement, because that doesn't work. Have them parrot it back to you. Again, the retainer options are all over the map. You can have automatic termination. We're going to stop this relationship in June, and wherever it is, that's where it is, and we're done. You can say, let's change this relationship, And when you change the relationship, you have to have a writing that changes the relationship and says, I'm going to extend this past June, but only until August. And if we have not completed X, Y, and Z by August, we're still done. You can have you can have the options in limited scope are endless. And that's where Sue's checklists are really fabulous, because it is like a recipe. And if you don't happen to like black beans in your chili soup, then you just eliminate that, and that's off the checklist, off the recipe. It's the same thing. I'm going to do this and this for you, but I don't like appearing in court. I will not appear in court with you. No, I will not assist you with the deposition. All of the different phases of litigation, which are defined in the Rules of Civil Procedure. And but now you are allowed to say, I'm going to do this part, but not that part. So Sue Talia, Talia. When to execute? Well, she says when prudent or necessary. I say straight out of the chute. I mean, I don't think I would want to go too far down the road unless you're dealing with the programs that Janice is talking about. The programs that Janice will be talking about give you opportunities to do this without all of the checklists. But if you're doing it on your own behalf as in a for-profit situation, or you're saying, I'll do all of your initial filings for $1,000, you want to define exactly what those initial filings are, what they entail, and how they work. So I would say you do it right out of the chute, and then they're talking about when at the different stages where you're talking to others and how you're talking to others, and you want to make it really clear when you are talking to people, not your client and not opposing counsel, well, including opposing counsel. Opposing counsel, here's what I'm here for and here's what I'm doing. But if you've got your good initial fee agreement and your initial statement, you're all set. So, again, everything must be informed, which is a defined term, and in writing. And you're in a position, and this is one of those slides you actually want to read to yourself. I'm not going to read it out loud, but you need to be reasonable when you pick a limited scope client. There are so many unsophisticated people out there that are more than happy to give you information and have you tell their story, but they may not have a clue when you're talking about what it is that you're doing with a limited scope. And I'm going to give you a good example because I get a call about this from the disgruntled clients that I speak to on a regular basis. And if I don't get a call every couple of weeks about this, I'm surprised. And a really good example of one of the more recent calls was a client had called and said, when the attorney was done, the attorney told me to file this document. And so I did. I put it in the file that I'm keeping on my litigation. And what the attorney was saying is trot it up to the courthouse and file it with the clerk of court and pay the filing fee. And as a result, the client's statute of limitations was blown. And the attorney and the client were both in disagreement. However, the fact that the client heard the word file and thought one thing, and the attorney said the word file and thought another thing, where do you find the middle in that situation? So again, having the clients repeat back and not picking or not using limited scope with people who need more complete representation, or making sure you're making arrangements so that the entire range of issues that they're going to be addressing, they're going to have enough assistance so that their representation of their self can be competent and intelligent and effective. That's the critical part. You want it to be effective. So, nice broad range of all of the different issues that can be covered in limited scope. Yes, limited scope has always existed, and it has always existed in each of these areas, child support or visitation, but especially in the business arena. But now all of these lovely protections have been carved out to encourage pro bono. And these are some of the tasks that are on the checklist that tell you, here's what I'm going to do for you, client. You get it all set up. Here's what I'm going to do. I'm going to, for example, draft your initial pleadings and help you respond to the pleadings filed. And then I'm not going to do anything until you're in court. I'll take a look at it and I'll show up and I'll sit with you in court and I'll try and make those representations. But that's all I'm going to do. The rest is up to you. If you don't give me the material and the ammunition I need to make your case in court, that's your issue. So when you look at these checklists that are available, you're going to be seeing all the tasks that are part of the process. And here are a few more of the tasks. I mean, when they see the full range of tasks that are part and parcel of this process, they may say, you know, I'm going to have to come up with some more money because I realize that in order to be an effective advocate for myself, I'm going to need your help. So how do you go about finding the resources? Well, the coolest thing about limited scope is how many resources are available. Right now, there's a complete flow of resources, and they are a phenomenal variety. First place I'd start is the State Law Library if you go to mt.gov, or if you even Google Montana limited scope representation, you're going to get taken directly to the Law Library or to the Supreme Court's website. Those are your first two choices. Another place that doesn't show up right away but has phenomenal forms and good glossaries and good models and great examples and narratives is the Montana State University Extension Service. Of course, there's the Montana Legal Services Association, which has a phenomenal set of resources. They have montanalawhelp.org, and spell out Montana, MONTANALAWHELP.org. And I even know a lot of lawyers who start there when they're doing some limited scope representation or any pro bono, because again, the forms are there, the checklists are there, the ideas that people need to be alert to. On the montanalawhelp.org also will probably link you over to the interactive forms that Montana Legal Services has. I don't know if you're familiar with interactive forms, but that's one where you can put your name, your address, and the details in, and then when you click, it automatically fills out a pleading for you, for example. You put the names of the ages of the children in, and poof, it gets tucked into the pleading. And Janice will will catch what I missed here with the Montana Legal Services Association. Modest Means is a program that is operated out of the State Bar Office at this moment with an AmeriCorps volunteer named Andrew Rodriguez, and he is a phenomenal resource. Modest Means is that you're not getting the service for free. You're still paying for the service. You're just not paying the $200 an hour or $100 an hour. You might be paying $25 an hour. But you can talk to Andrew about that and say, here's what I'm capable of paying. And there are quite a few attorneys that are happy to be signed up. And this is a program that Janice Doggett got up and running a few years ago, and it's going full bore now in 2016. There is a lawyer referral service. It's limping, so I'm not sure I would use it. I would go straight to the Modest Means program. There are limited scope clinics, and the first contact there says Erin Ferris Olson, and that person has changed to Ann Goldes, so I'm sorry I didn't change the slide. Ann Goldes is at the State Bar Office, 442-7660, and Goldes is her last name. And these are some of the other resources that are available to you, and I've been told that calling Angie Wagon Halls, is the way to go if you're looking for a direct connection. And then the last resource is probono.mt.gov. It's fabulous, and it's not here on the slide, but that's what it is. It's probono.mt.gov. And that concludes my portion. Janice is going to talk about what is qualified pro bono. Thank you for your attention.
Hello, my name is Janice Franchino Doggett, and thank you very much, Betsy. That was very, very informative. Betsy and I worked together quite a bit on the access to justice issues. I was the Equal Justice Coordinator at the State Bar after I decided to be in semi-retirement. I'd been chief counsel for a couple secretaries of state and state superintendent of public instruction, worked with school districts and lots of other entities before I decided that what I wanted to do was focus on access to justice in Montana. And I have to thank Betsy for her hard work on the limited scope representation presentations. But I think we'd be remiss if we didn't thank Andrew King-Reese, who was chair of the Equal Justice Task Force, Judy Meadows, who was chair of the Commission on Self-Represented Litigants, and Beth Baker, who is now the chair of the Access to Justice Commission. The Access to Justice Commission was formed when those two other entities voluntarily agreed to disband and create a commission that created broad-based support in Montana from a lot of different professions, not just the lawyers and not just the paralegals, and not just the courts, but the medical community, the business community, and the communications community. So I wanted to give a shout out to those individuals. As far as limited scope representation, Judge Fagg out of Yellowstone County was tremendous in his efforts to make sure that limited scope representation was fair, available, and clear. With that, I'd like to turn it to the next slide of Montana AAA Legal Services. As Betsy mentioned, there are extraordinary resources in the state of Montana for individuals who are self-represented litigants, want to use limited scope representation, or for attorneys who want to practice pro bono. And we're all working together. Currently, we're working on a grant where Montana Legal Services is involved. All of the local bars have been invited to participate through the State Bar of Montana, and the State Bar of Montana has been instrumental in its efforts to improve the lives of individuals through access to justice. Through this grant, we are collaboratively working on reaching out to elders in Montana or seniors in Montana. And so that's kind of what the impetus for this continuing legal education was. We saw a real need to create Indian Wells and disability documents, frankly, for individuals who are tribal members. And so I'm delighted to be part of this presentation, and I'll talk a little bit about what pro bono is. I'll be speaking primarily from the perspective of an attorney and what an attorney needs to do. But for those of you who are non-attorneys, I hope to make it interesting enough so that you can understand what our requirements are and what they are not. What is qualified pro bono? We have a rule in the state of Montana that every lawyer has a professional responsibility to provide those who are unable to pay 50 hours of pro bono service. Now, you want to look at the red word there. A lawyer should render the 50 hours. It doesn't say must in Montana. It said may render in the ABA rules, the national rules. And our Supreme Court modified it to make it stronger, but it's not a requirement, but a lawyer should render at least 50 hours of pro bono service. We have an extraordinary support for the pro bono practice and participation in the state of Montana by attorneys. And the states near and around us envy the number of attorneys we have practicing and the number of hours they perform. But we still can't meet the need of those who are unable to pay. And the self-help centers have been set up for that, and we have lots of other programs working together to try to eliminate or alleviate that burden to the court system. We have a tiered approach, and I'll talk a little bit in detail about that, because there are certain hours that qualify, and then there are certain additional hours that will qualify for additional hours. Let's talk about that. It's confusing. Next slide. A substantial majority of the 50 hours has to be performed in one type of service. And I think the best way to think of that is, does it benefit directly persons of limited means? Does what you're doing ultimately benefit directly persons of limited means? Then it will fit in the substantial majority of your 50 hours. Then there are additional services that the rule provides that you can also provide individuals. These are substantial majority hour qualifiers. Representing a person of limited means directly. And this can be providing legal advice, preparing documents for low-income seniors, drafting documents, doing any of the limited scope representation Betsy just talked about, or taking a full case. It's representing a person of limited means without an expectation of fee. Representing a client referred by a pro bono program and providing legal advice to an individual living in poverty at a clinic. The second aspect is to an entity, but the matter must primarily benefit individuals of limited means. So you can represent the organization, charitable, religious, civic, community, governmental, but the matter must primarily benefit individuals of limited means. Example, preparing a program or documents for the Legal Services Developer Program or Montana AAA Legal Services. Preparing incorporation documents for a nonprofit or low-income seniors. Delivery of services at no fee or substantially reduced fee to individuals or groups seeking to secure and protect the rights of individuals. And in this instance, it can go to their organizational purpose. It doesn't have to be directly to the person of limited means. So when we talk about your substantial majority, it's direct representation, organizational representation that ultimately benefits individuals of limited means. The additional hours would be spent in matters in furtherance of organizational purpose of the organization that support those individuals, where the standard fee would be unfair or would deplete the organization's resources. And you can see the examples there. And this would be lobbying is one good example of something that you could do for an entity in this context. Delivery of legal services at a substantially reduced fee to persons of limited means is also an additional way to gain pro bono hours. Now, this can't be the case where somebody doesn't pay you. In order for it to be pro bono, you have to do it without expectation of a fee. But in this case, you're providing those services at a reduced fee upfront, the agreement. And Montana AAA Legal Services, we talked about before, it has the same kind of program that the state bar does in terms of modest means. It represents seniors in poverty. It also has a modest means program, and it has a full pay program. So that if you sign up as an attorney with the Montana AAA Legal Services to do these kind of wills, the Indian wills, or we have clinics to do other kinds of wills and documents, we will train you, we will assign you clients, we'll have you come to a clinic, or you can do a phone clinic, but you could also end up getting full pay cases as well as modest means. Participation in activities for improving the law or the legal system. Now, I have friends who do their 50 hours in this area, but that does not technically qualify as pro bono under the rule, because the substantial majority of hours have to be work that we do that directly impacts the lives of those individuals with limited means. And there are more resources and additional information on probonomt.gov. There are also some pretty good resources and information on the Montana Supreme Court website under pro bono. And there are organized local pro bono programs in the counties around the state of Montana, and that's also on the Supreme Court website. Many of the organized programs in Montana provide the protections that Betsy was talking about for limited scope representation. I would inquire, though, if you're volunteering for clinics or programs, to be sure that they have the exceptions covered so that the organization is operating under those exceptions to the limited scope rules, which require you to have the notices and the filings. And finally, as Betsy mentioned, the American Bar Association Resource Center has excellent resources on limited scope representation, Sue Talia, and don't forget to check out the Montana AAA Legal Services website. Thank you for your attention.